defense by the prosecution. If you are present virtually, you can introduce yourself.
Quorum for the accused person.
Let me just finish. I have seen you on the meeting.
The others here wanted to put them on quorum.
So for the defense, I've written Mr. Dr. Amin, Mr. Matt, and other counsel as before. I've done the same for the victims.
Much obliged. Start there. We can proceed.
Judge, this is a total of 6 counts. The accused person pleaded not guilty to each of the 6 counts facing him. The prosecution objected to release of the accused person on bail bond pending trial, while the defense has sought release of the accused on bond pending trial. The advocates for the victim, having been allowed by the court to participate in the of sections 6 and 9 of the Victims Protection Act, did also address the court on the question of bail bond. At the hearing of the application, a number of the advocates from the side of the prosecution and the victims made submissions at length. And since the prosecution bears the burden of proving existence of compelling reason as to why an accused person should not be released on bail bond pending trial in line with the provisions of Article 49, Sub-Article 1H of the Constitution, submissions on the side of the prosecution are made first. I have considered the submissions made by the counsel for the prosecution and for the victims who made their submissions at the hearing of the application. That is Mr. Wood, Mr. Owiti, and Mr. Njue for the prosecution, Mr. Deuri, Mr. Odhiambo, Mr. Mwenda, and Mr. Nicholas for the victims. Each made submissions on as to the existence of compelling reason as to why the accused person should not be released on bail bond pending trial. At the end of submissions of the said counsel, the defense counsel sought time to make their submissions in response on another day, and this court allocated a date of today, 23rd of October 2023. Today, Dr. Aminwa and Mr. Omari, advocates for the accused persons, have indicated to the court that they do not wish to make submissions and would let the court make a ruling other than the submission that no compelling reason has been presented to the court. The defense also indicated that the accused person filed affidavit today, sworn on 21st of October 2023. Mr. Omari did indicate that he wishes to withdraw the said affidavit. on the face of the said affidavit, there is indication that the same was filed today and served on the prosecution today at 23rd of October 2023 at 11:07 a.m. An affidavit contains statements on oath which, once filed, can only be withdrawn by the deponent of the affidavit on oath, so that an advocate on record cannot be allowed to withdraw statements of oath made from court. Nonetheless, the said affidavit was improperly placed on record after the prosecution had already concluded their submissions on the application to have the accused person denied bail on Thursday, 19th of October 2023, and being improperly on record, the same is expunged from the record on the basis of that irregularity. For the purposes of clarity, it is important to indicate at the outset that the contents of the said affidavit, having been so expunged, do not therefore form part of what the court has taken into consideration in this ruling. The prosecution and the victim's advocates made quite substantive applications for 3 hours in total, reciting all submissions made in this ruling would have made it quite long, and therefore, with respect, I do not consider it necessary to reproduce the submissions in this ruling, though I will be making reference to the same as I proceed on, and as already indicated, I have considered all the submissions made by all the counsel who addressed the court at the hearing of the application. This court has not considered it necessary to call for filing of a prevail report in this matter, as was sought by the prosecution, as the submissions made are enough to determine the application on its merits in order to avoid unjustifiable delay to the detriment of either party. The main point for determination is whether the prosecution has established the existence of compelling reason or reasons as to why the accused person should not be released on bail or bond pending trial in line with Article 49, Sub-Article 1H of the Constitution of Kenya. On this, I am guided by the bail and bond policy guidelines, which provides at page 25 thereof as follows, and I have reproduced it, and I propose not to read it. The principal consideration in every application for bail or bond pending trial is whether an accused person, if released, would turn up for trial. That position is stated in the case of Twaiba Hashim in Cambia 3 others versus Republic 2014 EKLR, where the Honorable Justice Bogoli Musaga J, as he then was, said, I quote, "The basic consideration in application of this nature is whether or not the applicants shall avail themselves before the court to take their trial." End of quote. The provisions of Article 49, Sub-Article 1H of the Constitution of Kenya is to the effect that every accused person or arrested person is entitled to be released on bail or bond pending trial unless there is any compelling reason as to why he or she should not be so released. A key consideration, therefore, is whether the prosecution in this case has established the existence of any compelling reason as to why the accused person hearing should not be released on bail or bond pending trial. While dealing with the question of what amounts to compelling reason, the High Court, in the case of Benjamin Njiru Bidan versus Republic 2021 EKLR, said as follows, I quote, the Court of Appeal in Michael Juma Oyamo and another versus Republic 19 ELR adopted the definition of the phrase compelling reason in the case of Jackson, Malende, and 3 others, criminal case number 63 of 2009, where the learned judge held as follows: quote, the phrase compelling reasons would denote reasons that are forceful and convincing as to make the court feel very strongly that the accused should not be released on bond. Bail should not therefore be denied on flimsy grounds, but on real and cogent grounds that meet the high standards set by the Constitution. Unquote. Submissions were made with regard to specific reasons advanced by the prosecution counsel and by the counsel on record for the victims. I shall therefore proceed to deal with those. The first is whether the accused person is a flight risk. Submissions have been made by the prosecution counsel and the advocates appearing for the victims to the effect that the accused person herein is a flight risk. It has been submitted that the accused person made a statement in the social media that he was to appear at the office of the Directorate of Criminal Investigations at will, and that the accused person made the statement on Friday, 13th of October 2023, but failed to appear at the offices of the Directorate of Criminal Investigations until 17th of October 2023. That part of the statement that was made by the accused person and his associate with whom he appeared on social media was that the accused person had the intention of going out of the country on sponsorship by the associate to study law, and on the premise of that submission, counsel contended that the accused person is therefore a flight risk. In support of this submission, Mr. Euri Advocate relied on affidavit sworn on 18th of October 2023 by one Florence K. Vituri and made references to a video clip in the same affidavit, which he played in open court in the course of his submissions. There is attached to the said affidavit a certificate made under Section 65, subsection 8 of the Evidence Act. Every document attached to an affidavit as an exhibit must, as by law required, bear a stamp signed by Commissioner of Courts who commissioned the affidavit to which a particular exhibit is annexed. Rule 9 of the Oaths and Statutory Declarations rules provides as follows: quote, all exhibits to affidavits shall be securely sealed thereto under the seal of the Commissioner and shall be marked with serial numbers of identification. End of quotes. In this case, the document in question does not meet the legal requirement as contained in the said rule, unlike the rest of the annexures to the said affidavit. The same is therefore not properly on record. There was need for evidence of the investigating officer by way of an affidavit that the video clips that were played in court during hearing of the submissions by the advocate for the victim were subjected to analysis at the Cybercrime Unit of the Directorate of Criminal Investigations using appropriate tools to confirm that none of those videos was neither interfered with nor was a product of artificial intelligence. Encyclopedia Britannica says the following regarding artificial intelligence, and I quote, artificial intelligence, the ability of a digital computer or computer-controlled robot to perform tasks commonly associated with intelligent beings, The term is frequently applied to the project of developing systems endowed with intellectual processes, characteristic of humans, such as the ability to reason, discover meaning, generalize, or learn from past experience. End of quote. In my assessment, the video evidence is neither sufficient nor reliable enough to support the submission that the accused person is a flight risk. It would be dangerous to rely on the clip as evidence without a background contextual basis of its existence being laid by way of viva voce evidence and tested. I have gone through the record, and what is clear from the record on the face of the charge sheet is that the accused person, prior to preference of the charge and arraignment of the accused person before the court to take plea, he was out on police cash bail. He was out on cash bail granted by the police, and then he turned up voluntarily to take plea. There is no reason enough for this court to believe that the accused person, if released on bond or bail, is not likely to turn up for his trial. There is no information on record by the investigating officer indicating that the accused person was at any one point summoned to appear before the investigating officer and failed or neglected to do so, and to appear at the time or place as required of him in the summons. One thing that must not be forgotten is that the accused person under Article 50, Sub-Article 2, 1A of the Constitution enjoys presumption of innocence throughout the trial. The same provides that, I quote, every accused person has the right to a fair trial, which includes the right, A, to be presumed innocent until the contrary is proved, unquote. Number 2, likelihood of interference with witnesses. The second ground advanced is that the accused person is likely to interfere with witnesses if he is released on bail or bond pending trial. The prosecution submitted that the accused person is likely to interfere with witnesses in this case. The manner in which such an allegation is made should be handled by the court has been explained in two authorities, that is, Panju versus Republic, 1973, East Africa Law Reports at page 282, and Jeffa versus Republic, 1973, East Africa Law Reports at page 39. In the latter mentioned case, it was held as follows, I quote, time and again, this court has said that the true test of a bail application is whether the granting of the application would be detrimental to the interest of justice. It is for the prosecution to satisfy the court that this would be so if bail was granted. Dealing with question of tampering with witnesses, Wilson, acting CJ, as he then was, said in Bagwanji, Kukubai, and Republic, 1, Volume 1 of Times Law Reports, at page 43, quote, the tests laid down in English cases were that there should be a definite allegation of tampering or attempted tampering with witnesses, supported by proved or admitted facts, showing reasonable cause for the belief that such interference with the course of justice was likely to occur if the accused was released. In this case, there was no more than mere assertion by the prosecution that the applicant would interfere with prosecution witnesses if released on bail. There were also fears that he would abscond. There was no evidence whatsoever to support these hypothetical fears. And further quote, in Republic versus Anthony Karanja Jeru, 2016 EKNR, the High Court said, quote, as it has long been recognized that an accused person who interferes with witnesses does not qualify to be granted bail. In Panji versus Republic, the High Court held that where an allegation of interference with witnesses is used as a ground of opposing release on bail, the prosecution must produce evidence. This was the practice under the Independence Constitution of 1963. The requirement to produce evidence to support an allegation of interference with witnesses is, in principle, good law. The reason being that a decision of a court must be based on evidence. End of quotes. In Republic versus Gerald Mutuku, Nyalika and another, 2015 EKLR,